Guys, hope you all are doing well. So let's start our session today. Today we are going to start with section 5 of Companies Act. It's Articles of Association. AOA. So what is Article of Association? Basically, Article of Association is nothing but the rules and the regulations that are applied by the company or which are followed by the company. As articles of association, what are mentioned in article of association? Some rules, some regulations which are followed by the company during the business. Start with subsection 1. Article of association means article of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law of this act. So, what is article of association? Article of association of a company, it is originally framed. So, at the time of incorporation of the company, we will be framing our articles of association. That is the original article of association, or as altered from time to time. As we do the business, we will alter our articles of association. So that is also considered to be article of association, or it is applied in pursuance of any previous company law of this act. So suppose before 2013 you have started your business under 1956 act. So that article of association is also considered in this act. Next section. It shall also contain such matters as may be prescribed. Plus, it shall also contain such matters as may be prescribed, plus it can put additional matters too. What does this mean? Like, suppose there are some rules where you should where the rule says that these rules are to be followed when you prepare your articles of association. These are those what you should include, what you should not include. These are the rules that how you should build your article of association. Plus you can put additional matters into it. Like if you want to add something specifically for your company, then you can add it. The third subsection comes with it can contain provision. Can contain provision of entrenchment. It can contain the provision of entrenchment. What does this word mean? Entrenchment is nothing but something that makes us difficult to do or makes us difficult to change. Something which is difficult to change. The word meaning is something which is difficult to change. Entrenchment. Usually articles of association can be altered by passing special resolution, but entrenchment makes it more difficult to change. So if company want, they can include this provision too. Fourth, when you can include this entrenchment, This you can include at the time of formation, or if you want you can even include it later, not at the time of formation. Even if you want you can add this provision later, but for private company all members should accept, and for public company special resolution shall be passed. To add this provision in a private company, all members should give their acceptance, whereas in public company only special resolution needed to be passed. Let me give you an example to understand this word entrenchment. Suppose there is a private company. And Mr. A is director, and all the shares are held by his family, held by family members. He is so intelligent. So what they did is, at the time of incorporation, they added in their articles of association that if they want to remove Mr. A, they should pass 95% of votes should be favor in resolution. If they cast whole 95% of votes, then only he can be removed from his post, or else he cannot be removed. This concept is called as entrenchment. So if you add that Mr. A can be removed only if 90% of votes are cast in favor of the resolution, then only Mr. A is removed from the post of director. Subsection 5. The notice of entrenchment shall be given to the registrar that you are adding this clause, you are adding this provision. You should have to give the notice to the registrar. And there are some forms for articles of association that are contained in Schedule 1, Table F, G, H, I and J. And 7th one, it is optional, like, listen properly. Company may adopt all or any one of the provision contained in the act at the time of incorporation. When you suppose at the time of registration, while framing your articles, you have adopted some provisions from the Companies Act and some you have excluded, then there is no problem. If you want, you can include those provisions, and if you don't want, you can exclude those provisions. It is an optional to the company to adopt all the provisions that are there in the act. So that's all about your section 5. Let's move on to next section. Section 10. Effects of MOA and AOA. What does this mean? On the basis of MOA and AOA, company is liable to members. Members are liable to company. In general, members are not liable to each other. Company is liable to member. Members are liable to company, but members are not liable to each other. Money is payable by any member. Money is payable by any member to the company that is mentioned under AOA or MOA. It shall be considered to be debt due from that member to the company. On the basis of MOA and AOA, company is liable to the members. Members are liable to the companies, but in general, members are not liable to each other. Any money that is payable by the member to the company shall be considered to be debt due. That's all about section 10. Let's go with other. So let's start with section 13. Section 13 is nothing but alteration of memorandum. The first thing that you should do to alter your memorandum is take special resolution from the members. This is must. Take special resolution from the members. Next, if there is name change of the company, then it should be approved by central government. Now this power is delegated to ROC. So if there is name change, there should be approval from central government. Suppose there should be approval from the central government. You don't have to take approval. No approval is required. If there is any addition or deletion of limited or private limited due to conversion of company. Suppose a private limited is converted into limited, so you should have to delete this name. You don't have to go and take the approval for this purpose. It's just normal way. That normal way is nothing but that subsection 2 and subsection 3 of section 4 that we have already studied of section 4. You should have to follow that. Company rules 2014 says, you should have to study this rule for this section. This company rules 2014 says, no change of name shall be allowed to a company. You cannot change your name. Why you cannot change your name? Suppose you have not filed your annual return or financial statement due for filing to ROC. You have not filed your annual return, you have not submitted your financial statement to the ROC, then you cannot go for name change. Or you have failed to pay, or you have failed to repay the matured deposits or debentures or interest thereon. Suppose you have done these two, then you cannot go for your name change. What are that? Not file your annual return, or your financial statements are due for filing to the ROC, and you have failed to pay, or you have failed to repay your matured deposits or interest on these debentures, then you cannot go for name change. Third one, change in name. You go to registrar, it will enter new name in place of old, and it will issue a fresh certificate of incorporation. In case of name change, if everything is accepted, you will go to registrar of companies. It will enter new name in the place of old name, and it will issue your fresh certificate of incorporation. Suppose you want to change your registered office address, then section 4 says there is change in registered office from one state to another. If you want to change your registered office from one state to another, in this case you should have to take approval from the central government. Approval from the central government is required to change. Central government can give the approval in 60 days. To change the registered office, it will give the approval in 60 days. But before passing the order, central government will satisfy itself with what does it do? Alteration has consent. Right? For this alteration, central government will take the consent from creditors, debenture holders, other persons who are related with the company, other persons. All this consent is taken from creditors, the consent is taken from debenture holders, and any person who are concerned with the company. Central government will take the consent from them. Next, sufficient provision is made by company. Provision for what? The company has made sufficient provision to discharge all its debts and its obligations. It has made all its provision to discharge all its debts and obligations, and or adequate security has been provided for such discharge. Suppose there are some debenture holder who did not satisfy for that, then you can discharge those debenture holders, or you can give them little more security so that they will accept for the change. Company with special resolution and approval from central government, they can go for registered office change and also name change. Next, change in registered office from one state to another in a simple way will go. The company should take central government approval. After the approval, register will remove the old address. It will remove the old address, register the new address, and issue new certificate of incorporation. Once you have passed the special resolution and taken the approval from the central government, then what does registrar will remove the old, it will add the new address, and it will issue a new certificate of incorporation. Now, change in objects. At the time of change in object is nothing but your nature of business, or you are going to add some of the other object into your business. Then any unutilized amount collected from public through prospectus. What is prospectus? In the prospectus, you will collect the amount from the public, saying that you are going to start some project. So they will invest their money by thinking that you are investing into some project. And if you change the object of that project, then any amount that is left, you should have to take special resolution from them. And the details of special resolution published in newspaper. One should be in the English newspaper and the other should be in vernacular language. Vernacular language, nothing but the local language where registered office is situated. Suppose your registered office is situated in Telangana, so you should have to publish in English newspaper as well as one Telugu newspaper. You should have to publish the details of special resolution as well as justification giving for change. Why you are going to change your object, that you should have to mention, along with the approval that you have taken from the members. All this should be published in a newspaper. One should be in English and other should be in a vernacular language. And also you should upload in the company website. There will be some shareholders who do not accept for the change. Those are called as dissenting shareholders. So dissenting shareholders will be given a chance. What chance they will be given? They will be given a chance to exit. They can exit as a promoter or they can join the majority shareholders. Next, registrar will certify the change within 30 days of filing of special resolution. From this special resolution date, it will take 30 days. Once you file this special resolution with the registrar, within 30 days it will certify the change. So that's all about section 13. Let's start with section 14, articles of association. Section 14, alteration of articles of association. Even though if you want to alter your articles, special resolution shall be passed. It should, including alterations having the effect of conversion. Even if you want to convert from private to public company or a public to private company, you should have to pass special resolution of a public company into a private company, private company into a public company, provided, you should have to follow this, provided when a private company is altering its articles, when a private company is altering its articles, when it is converting into a public company, it should alter in such a manner that the restrictions and limitations that are required by a private company no longer exists. The restrictions and limitations shall be removed. After it removed, it should be ceases to be a private company. Once it is removed, it cannot be called as a private company. It will become a public company. In case of public company, provided public is converting into a private company, application shall be given to the central government for approval. Once you get the approval from the central government, you take the special resolution copy plus the order passed by the central government plus what you want to alter in your articles. All these three are submitted to the registrar, and registrar within 15 days it will register the change. That's all about section 14. So let's end this class today. We'll meet you in the next session. Please like, share and subscribe my channel. Thank you guys. Have a nice day.